Hi, I'm Matt Blake, General Counsel of the Iowa Association of Realtors, and I'm here today with...
I'm Noelle Young, and I'm the legal intern.
And we're here to talk today about surveillance equipment in homes, specifically about how that interactions with real estate agents and the surveillance equipment. So Noelle has done some phenomenal research on this topic, so we're here to discuss, and Noelle is going to be taking the lead. So before we begin, let's figure out what is surveillance equipment in a house. What comes to mind?
One of the most common home surveillance devices are Ring doorbells. So those come equipped usually with audio and video options. You can then have that video saved to your device and you can review it as many times as you'd like. Some other common devices include exterior cameras, pet in-home devices, and nanny cams for babies.
Okay. And do issues with this come up often with realtors?
Questions and concerns about surveillance devices have grown and become more common. One of the more frequent questions that's being asked is, are people allowed to use cameras to listen in on conversations when someone's touring a house?
So do I need permission in the state of Iowa to record someone?
No, Iowa is a one-party consent state. Iowa Code 808B22B states that when interpreting a wire or electronic communication, if the person is a party to the communication or one of the parties to the communication has given prior consent to the interception, then the recording of audio and video is permissible. For example, you can record a conversation with your boss without them consenting to being recorded because you are the party to consent.
Really? Watch out, Gavin. So what if a party doesn't know they are being recorded?
As it stands now, only one party needs to consent. So again, whoever's doing the recording can be the party to give that consent.
So do we have any issues with this with NAR's professional standards and code of ethics?
Yeah, so NAR's code of ethics section that relates to this is 1-9, which addresses confidentiality. It states that an agent shall not knowingly reveal confidential information to their client. Two pieces of confidential information included in the Iowa administrative rules are whether a client is willing to pay more than asking price and whether the buyer would be willing to agree to financing terms other than those offered. If these topics are discussed during a showing and are overheard, negotiations can become skewed.
What if the client mentions these topics? Would they be in violation of 1-9?
No. If a client reveals confidential information, there is not a 1-9 violation. For a full list of these confidential topics, you can look at 193E 2.1 of the Iowa Administrative Code under the definition confidential information.
Okay. And so what are some tips agents can use with their clients?
My suggestion would be to take reasonable steps to make sure your client is aware of how to handle themselves when there's a possibility of surveillance devices being used. This may look like giving your client a summary of topics that they should not discuss during a showing so they don't accidentally give away this confidential information. You can always give them a reminder during the showing to keep them on track as well.
So that's with the buying agent. What about the listing agent?
Right now we're working on a section of the listing agreement to include surveillance device disclosure. This way the listing agent is aware of what surveillance devices are present and can make sure that other agents are aware when they come to view the property. The hope is this disclosure will help create a culture of transparency when it comes to home surveillance devices.
Well, that's fantastic. Well, thank you, Noelle, for all this wonderful research, and thank you for tuning in today.